My eligible obligation.
What are you talking about? What are you talking about?
I'm talking about eligible obligation on the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. If I hear it again, I'm not going to let you represent yourself. I promise you.
Oh,
that's enough. I don't want to hear another word.
Okay, I'd like to also.
Another one? I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard it.
All right, folks. Today's case is wild. We've got a guy facing 30 years behind bars. Yes, 30. And instead of hiring a lawyer like any rational person, he decided, you know what? I got this. Yep, he chose to represent himself. Now, we're either witnessing peak delusion or someone who simply doesn't care about their fate and just wanted to roll the dice for fun. Spoiler alert, it does not go well. The judge absolutely shuts him down, and what unfolds is some of the most chaotic courtroom drama you'll ever see. But seriously, why would anyone pull the sovereign citizen card when they're staring down decades in prison? What's the strategy here? Let me know your thoughts in the comments, and let's dive into this madness.
And let's see. You're not. Have you hired an attorney?
No, sir.
Do you plan on hiring one?
No, sir.
Are you going to represent yourself, or do you wish to have the public defender to represent you?
No, sir. I'm representing myself.
All right. You're before the court today for your arraignment. You've been charged by way of an information with possession of a cocaine, possession of a controlled substance, count 1 and 2. Those are both third-degree felonies, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. You have a count 3, which is fleeing or attempting to elude high-speed reckless. I believe that should be a second-degree felony, punishable to 15 years in the Florida Department of Corrections and a $10,000 fine. Count 4 is drive my license, cancel, suspend, or revoke third or subsequent offense. That's a third-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. And count 5, possession of marijuana less than 20 grams, which is a first-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. So you're looking at a total of about 30 years in the Florida Department of Corrections if you're convicted of everything and you get the maximum sentence. And you're still wishing to represent yourself?
How do you even look a judge in the eye and say, yes, sir, right after he tells you you're facing 30 years? Like, what? I seriously don't get these sovereign citizen types sometimes. I mean, I kind of understand someone pulling that card for a speeding ticket. Still dumb, but whatever. But 30 years? At that point, you've got to drop the act and face reality before it's too late. The court does not care about your made-up laws. Legally speaking, sovereign citizen defenses have never held up in actual courtroom. Not once. I don't know if this guy is aware of that. But judging by his performance, probably not. He's still fully committed to this nonsense, even while staring down a literal lifetime behind bars. There's endless case law proving this argument fails every single time. Yet here we are, watching someone throw their entire future away just for the sake of pride. So what do you think? Is he actually trying to outsmart the judge, or are we looking at something deeper, maybe even mental illness? Because at this point, I genuinely can't tell. Let me know what you think in the comments.
Yes, sir.
Mr. Baker, state your name.
Lee Baker.
And Mr. Baker, you have asked to represent yourself. Is that correct?
Yes.
How far did you get in school?
9th grade.
Okay. And so you can read and write?
Yes.
Okay. Are you employed?
No, sir.
All right. How do you make a living?
I'm unemployed right now. I was living with someone else.
Sir?
I'm unemployed. I was living with someone else. I just got out of jail about 5 months ago.
Okay. Well, what is your trade?
I have my own business.
All right. What kind of business?
A cleaning business.
Okay. And have you ever represented yourself before?
Yes.
All right. Let's see. Are you under the influence of any drugs or alcohol today, which would affect your ability to make this decision to represent yourself?
No.
Have you ever been diagnosed with a mental illness that would affect your ability to make this decision?
No.
All right. You understand that attorneys are trained in the rules of evidence, criminal procedure, and the law, and they're there to assist you in preparing pretrial motions, preparing for pretrial hearings, and to participate in discovery, and also preparing for trial.
I comprehend that very well.
All right, and sir, you understand that if you're representing yourself, you'll be held to that same standard.
I comprehend that.
All right, and I cannot assist you in any way. The state attorney would not be able to assist you in any way. Is that correct?
I comprehend.
All right, you still wish to represent yourself?
Yes.
All right, Madam Clerk, if you'll print out the information, and Deputy Dexter, it's okay if the clerk hands the information to Mr. Baker? All right, Madam Clerk, if you'll do that. Mr. Baker, when you receive that information, I'm going to ask that you enter a plea at this time.
I'd like to file 2 motions on the record as well, sir.
I want to do your arraignment first.
All right.
All right, whenever you're ready, you'll let me know and you enter your plea.
I enter a plea of not guilty.
Okay. All right, you're filing motions?
Yes, sir.
You have copies for the state?
Yes, I do.
Okay.
I got a declaratory judgment, and I want to furnish this bond to the clerk
You file it. Go ahead.
for my release from the Bay County Jail today.
Okay.
That's declaratory judgment. That's for the clerk only.
Now, you're providing a copy of the state, everything you've given the clerk?
The bond, I shouldn't have to give the bond. The bond goes straight to the clerk.
Anything you file that you want me to consider, you have to provide a copy to the state, sir. As you're representing yourself, you have to know those rules. If you don't, you're going to mess up.
I understand that.
If you're not providing to the state, I'm not going to consider it.
Okay.
And the clerk doesn't make any determinations on that. All the clerk determines is whether you're innocent or not.
I'm not talking about the bond for the declaratory judgment. I'm talking about the bond for the clerk to release me today. I filed my eligible obligation.
What are you talking about?
Sir?
What are you talking about?
I'm talking about eligible obligation on the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. And if I hear it again, I'm not.
Oh wow, he just said USCA, which means he's referencing the United States Code Annotated. For those who don't know, it's basically just the regular United States Code but with extra notes and explanations added by legal publishers. But let's be real, this guy probably has zero clue what it actually means. Sovereign citizens love to name-drop fancy legal terms like it's some kind of cheat code, thinking if they say the right magic words, the judge will suddenly go, "Oh wow, my bad. You're free to go, sir." Spoiler alert, that's not how the law works. And that whole eligible obligation thing, yeah, that's another made-up theory where they believe debts, including criminal charges, can just be wiped away like an unpaid parking ticket. Judges have ruled over and over again that this is complete nonsense. Yet here he is, acting like he just cracked the legal matrix or something. So, what do you think? Does he actually believe this stuff, or is he just throwing out legal jargon, hoping to confuse the judge? Let me know your thoughts.
Bro, don't ask me any questions like that, sir. I'm not answering any questions. If you want to file a motion, file your motion. We'll set it for our December, when's that motion day in December? December 19th at 9 o'clock. Sir, you may, if you're going to do the sovereign citizen and all that, you may want to consider having the attorney.
I'm a private citizen, sir. I'm not a sovereign citizen. I'm a private citizen.
Listen to me. If you're going to pursue that, you may want to reconsider representing yourself.
No, sir.
But I'm not going to pay attention to any of that, and I'm going to strike all that.
Okay.
So we'll see you December 19th at 9 o'clock.
It's no problem. Oh,
That's enough. I don't want to hear another word.
okay. I'd like to also.
Another one? I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. Whoa. Mr. Baker, I'm going to appoint the Office of Public Defender to represent you. I'm going to find that you're not competent to represent yourself at this time. I'm going to reverse my decision. The Office of Public Defender is going to represent him. We'll keep it on that December 19th date. I just did. Come on now. Y'all close that door where I can't hear him.
I'm not gonna lie, the judge actually did this guy a favor by dragging him out of the courtroom and forcing some real legal help on him. Some people might say the judge was too harsh, but come on, what was he supposed to do? Just sit there and let this guy recite his totally real, Definitely not made up legal theories, while the whole courtroom collectively lost brain cells. Yeah, no. The judge basically said, all right,